Well, good afternoon, everyone, and welcome to our webinar, Trust Me, the Importance of Background Checks. Thank you for joining us. We're not sure how many of you have been watching the BBC drama, Trust Me. It's highly topical for us as it's all about a nurse who is accused of bullying and misconduct after she raised a number of whistleblowing allegations. And as a result, she left and she's now fraudulently working as a doctor in A&E. Episode 3 is tonight, and that's when we wait to see whether the HR department realised that the passport she presented was a fake. Whilst this is clearly a drama, it's not entirely fictional. There have been examples of this happening in real life, both in the medical profession and others. So, as usual in our webinars, we will be looking at the law, but we also aim to give you some practical pointers and action points to help protect your business. Before we start, though, and for those of you who may not have attended any of our previous webinars, we'd just like to introduce ourselves. My name is Alison Blackhurst. I'm the HR Knowledge Manager at HR Solutions, and I will be leading the session. And I'm joined by my colleague, Sue Watson, our HR Operations Manager, who is busily answering any questions at the moment and who's here to field any technical problems. Now, hopefully we won't have any. We will be recording this webinar, and we do have copies of the slides which will be made available afterwards anyway. But we have experienced a number of problems with internet connectivity today, with things being a little slow. So I do apologize in advance if you see the slides loading more slowly than you would expect. If we have time for any questions, Sue will be monitoring those, so do send her a message and we'll deal with those at the end, dependent on time. If we don't have enough time, or because the question is particular to you or your working environment, then we'll email you with a response afterwards. So, background checks. Well, all employers have a legal obligation to check the right to work in the UK of any new employees they take on. In addition to this, it's worth considering any other pre-employment checks to ensure that you protect your organisation. There have been numerous examples of high-level appointments where candidates had lied about their qualifications, so the BBC drama that I talked about isn't actually that unrealistic. It's essential not only to choose the right person in the first place, but then to make the appropriate checks before that person starts to ensure there are no unwelcome surprises. Managers who are competing for talent in a tight labour market may well attempt to cut corners and to speed up the recruitment process, but there is a huge cost associated with hiring or promoting an unsuitable candidate. So thorough background screening is the first line of defence against poor recruitment decisions, and this can range from basic criminal records checks to a more thorough investigation, including reference interviews, credit checks, verification of qualifications and employment history, and DVLA checks for those who drive on business. But it's important to get the right balance. So any checks that you undertake should always reflect the requirements of the actual job, and you should only be investigating those aspects of the candidate's past that are relevant to their ability to do the job. And transparency is key. So it's sensible to inform candidates of any checks or screening early on in the recruitment process, as this enables you to discuss any concerns, and it may well also result in an unsuitable candidate withdrawing, which could save you time and money. If the checks uncover any areas of concern, then it's best practice to discuss your concerns with the candidate. Sometimes the information may be inaccurate, or there could well be good reasons and/or mitigating factors. So today we'll be taking a look at the following, and there's quite a long list of different sort of checks there. So I will be covering all of those fairly briefly. There will be more information on those later on for those that actually want it. Yeah. But the first question has to be at this stage, why bother? This sounds like an awful lot of work. Do we really need to do this? Now, most employers undertake background checks firstly, to meet regulatory compliance. That includes checking the right to work in the UK, which everyone has to do. And some employers have other required checks dependent on the role and the sector. But apart from just ticking the boxes for regulatory compliance, the reasons that other employers do this is to improve the quality of the candidates, because candidates are less likely to lie or to make fraudulent claims if they know that the information they're providing is going to be checked out. It's good for the employer's reputation because they are seen to be thorough and diligent and to be following a comprehensive recruitment process, which candidates do like. It makes them feel secure. They do it to reduce safety and security risks because, of course, employers can be found vicariously liable for the actions of their employees. So it does make sense to check driving licenses and to check gas safety certification, etc. And they do it to increase retention as well, because better suited candidates are more likely to perform well and they are less likely to leave. The biggest challenges to performing background checks are, of course, lack of time and lack of money. So let's have a look at application forms, first of all, because that's something that you will all be familiar with. And we do feel that it's still always a good idea to ask candidates to complete your own application form if you have one, even if the candidates have already sent you their CVs. Now, this is because most application forms will ask for specific information that might not be included in a CV or a covering letter. And what I'm meaning by that are things such as the confirmation of the eligibility to work in the UK, details of any criminal convictions which are not spent and covered under the Rehabilitation of Offenders Act, the contact details of the referees, any equal opportunity monitoring information, and also details about whether candidates saw your vacancy so that you can measure the effectiveness of your recruitment process. You can also ask candidates to sign at the bottom of the application form to confirm that the information they're providing is accurate and truthful. Now, obviously, a statement like that is something that they wouldn't normally include on a CV, but it might just actually make them stop and think as to whether they have over-enhanced their credentials a bit. Now, again, in terms of the law, under the Equality Act, employers are not allowed to ask disability or health-related questions prior to an offer of a job being made, except in prescribed circumstances. And to do this would put you at risk of a discrimination claim. Questions which are, however, clearly job-related may be included on the application form or at interview. So if you have a job which requires specific duties to be undertaken, such as a requirement to be able to drive to customers or to work at height up a ladder or to move heavy boxes around in a dusty warehouse, then you are perfectly entitled to ask about that. If a disabled person is unable to fulfill a requirement and you can't overcome that via reasonable adjustments, then your criteria may well be justified. So a further point in addition to your application forms is to suggest that your job descriptions and person specifications are up to date and thorough, so that the requirements of the role are clearly spelt out, and then you can simply ask a candidate if there are any duties that they wouldn't be able to undertake. If you give them a clear idea of the physical requirements of the job and someone is unlikely to be able to work safely in that environment, then you may find that they withdraw anyway. So steps to take regarding application forms: build the use of a standard application form, whether this be hard copy or online, into your recruitment procedures. Keep any equal opportunities monitoring information separate so that it is not used during the shortlisting or selection process, because that will avoid the risk of unlawful discrimination. Check that your forms don't ask for any pre-employment health details unless these are clearly justified by the role. And if you do need health information, then have a separate pre-employment health questionnaire which you issue along with the job offer. If appropriate to the role, ensure that the candidate completes a declaration about the Rehabilitation of Offenders Act and the barred lists for working with children or adults. And add a statement at the bottom of your application form, if you haven't already got it, which requires the candidate to confirm that the information that they're giving you is full and accurate to the best of their knowledge. and specify that failure to complete the form accurately will normally be regarded as gross misconduct and may result in immediate dismissal. So you're covering all bases with that. Now, checking the right to work in the UK. Now, I'm hoping that everybody here knows that it is illegal to employ anyone who doesn't have the right to work in the UK. And it is your responsibility as an employer to check that each successful applicant's documentation means that they are eligible to work. The penalties for failing to do this or for employing an illegal worker are up to £20,000 for each illegal worker. So it's a high penalty. But the penalty for knowingly employing an illegal worker can include imprisonment for up to 2 years and an unlimited fine. So basically, you need to see one or more approved documents, and the approved documents fall into two lists. Those that are in List A establish that the person has an ongoing entitlement to work in the UK. That would typically be a passport. And documents from List B indicate that the person may work in the UK, but they have restrictions on their entitlement to be in the UK, and you need to comply with those. Now, these checks must be made before the employment begins, and to avoid any allegations of discrimination, it's best to treat all of your applicants in exactly the same way, even if they appear to be of UK or EU nationality. You will find that passports are the most common form of verification that employees give to you, but you do need to be aware that each year the Passport Office issues over 5 million passports, and it's been reported that 16,500 fraudulent applications were received in a single year. There's also the risk of lost or stolen passports being misused, and in December last year, the Passport Office had a national campaign to try and reduce the risk of individuals using passports as a form of age identification in bars and clubs. And the passports were then lost or stolen, and they potentially fall into the hands of criminals. So the Passport Office is encouraging students and any young person who's been using their passport to prove their age to use alternative documents. There is something called PASS, which is the UK National Proof of Age Accreditation Scheme, and that's a photo identification card which is relatively cheap to buy. So I guess the point I'm making here is that you may well be well used to seeing passports as the form of verification, but do look at the passport to see whether it appears to be the right one. Also note that if you provide accommodation for your worker, then all private landlords in England, as well as anyone who sublets or takes in lodgers, must check that new tenants have the right to be in the UK before they rent property to them. Now, right to rent checks are very, very similar to right to work checks, and they can be done at any time from 28 days before the start of a tenancy agreement. And the aim is to deter foreign nationals from staying here unless they do have the right to live, work, and study here. Now, there is a code of practice which lists the acceptable documents, and the Government UK website also has an online checking tool to guide landlords through the process and also to request a check on anyone who has an outstanding case with the Home Office. Now, failure to make those checks are a separate penalty altogether, but that's a financial penalty of up to £3,000 per tenant. And finally, on this point, note also that if you are inheriting staff under a 2P transfer, then you will still need to carry out right to work checks, even if the outgoing employer has done this and confirmed that they have. You have 60 days following the transfer to ensure that no illegal workers have transferred. Some people are asking us, how will Brexit affect these procedures? Well, the short answer is that we don't know yet, so watch this space. But in the meantime, to check that you are legally compliant, we suggest firstly it's always easier to check these documents early on, such as at the interview stage. So ask your applicants to bring proof of their identity and of their eligibility to work in the UK with them, along with any other documentation that you need. If you haven't asked for it at the interview stage, then if you send out an offer letter or reporting instructions to new recruits, then use that to request that they either send the appropriate documentation to you or that they bring it with them on the first day, although it's better to get this done and out of the way before then if possible. Ensure that you make these checks for all new recruits prior to them starting work for you, even if they're already known to you, and ask them to contact you immediately if they have any queries or they're unable to provide the required documents. Always check original documents. You shouldn't be accepting photocopies under any circumstances. And take a good look at the document and consider whether it looks as if it does belong to the prospective employee. Are the photographs or the dates of birth consistent with the person's appearance? Have any expiry dates passed? Make a note of the details where the right to work is time limited or where there are other limits, such as limits on working hours for foreign students. Keep a photocopy of the relevant documentation, either in a separate file or on the individual's personnel file, or scan the documents and file the records, but make sure you make a note of the date you saw the original document in case you're challenged in the future. And if anyone contacts you because they think that they may be unable to comply, for example, they don't have a passport and they don't have any of the documents in List A, then inform them and confirm this in writing to them that you will try to keep the job open for as long as possible, but give them an end date after which the offer will be withdrawn. And confirm that if they're unable to produce the required documentation, then they won't be employed by your business. If you're in doubt, it's better not to allow the employee to start work until the checks have been completed to your satisfaction, because you do need to ensure that all your workers are legally entitled to work in the UK. Now, the next thing to look at is references, and we know that these have had a bad press and that many employers don't regard references as very useful, but it still always surprises us how many employers fail to take up references prior to someone joining them. This could be because of concerns about legal action for any breach of data protection have resulted in a trend towards shorter, more factual references that just confirm the job title, the salary, and the dates of employment. And frankly, you are unlikely to get the unguarded, open remarks about performance that you might have had years ago. But references are still an extremely good way of checking that the factual information on a CV or application form is correct. We've had plenty of calls to the helpline where references have unearthed discrepancies in job titles, salaries, duties, dates of employment, reasons for leaving, etc., which can then be discussed with the candidate. Now, except in certain sectors, such as financial services, employers are not under any legal obligation to provide a reference. But where one is provided, it must be accurate and it must be fair. But there's nothing to stop an employer from confirming a poor attendance record or from saying that they would not want to re-employ the person or they had concerns over that person's performance, provided that there is a reason for this. As long as the reference is fair and accurate, then the employee can't complain, even if the reference isn't to their liking. So we would still recommend that job offers are made subject to references which are satisfactory to you. And note that if you get an unsatisfactory reference before the employee joins you, you can simply withdraw the offer without giving them any compensation. Once they've started work for you, then you will have to give them either statutory or contractual notice, whichever is higher, if you dismiss. And employers' references are always preferable to personal ones from the candidate's carefully selected friends, because those friends may know little about the job or the candidate's work performance, and anyway, they're unlikely to say bad things about them. So steps to take. Always ensure that you make offers subject to satisfactory references. Try to take 2 references from the candidate, preferably the most current and the most recent previous employer. Make sure you have the candidate's written consent before you take up references, and warn your candidates when you intend to do this, especially if you have a practice of taking up references prior to a job offer being made and accepted, and especially if you're taking up references from the current employer. Check the job history, the reason for leaving, the positions held, and the dates of employment, preferably with the HR or payroll department, and compare this to the information that's on the CV or the application form. And ask whether the past employer would re-employ that person. Don't ask any disability or health-related questions if you're taking up references prior to making a job offer and it being accepted. But you can ask the previous employer to comment on timekeeping and attendance. And if there are concerns, then you can address these either at interview stage or before the person starts by keeping the questions related to the job rather than the person's health. So what we mean by that is, for example, if someone had a high level of absence in the previous job, instead of asking what health issues they have, ask if that level of absence was normal for them and whether it's likely to continue. Don't base your decision on that alone. Take all factors into consideration. And if you discover health issues or medical conditions, you will need to ensure that your decision is not unlawfully discriminatory. If in doubt, when you receive a reference, discuss the contents with the applicant and possibly the referee, and provide the applicant the opportunity to explain any discrepancies before you decide whether to withdraw the offer. Because sometimes inconsistencies, particularly in dates, may be a simple error. Check any gaps in employment, especially in regulated sectors, and chase up references if they don't arrive promptly. And if necessary, postpone the candidate joining you until you have them. Sometimes it helps to let the candidate know that you're still waiting for references because they may well be able to chase them up. Driving licenses. Now, a lot of our clients do take up copies of driving licenses, and if the job is going to require the employee to drive on business, even on an occasional basis, then you will need to ensure that you check their driving license, again, preferably at interview stage, but at the latest during the induction process and certainly prior to allowing the employee to drive on business. It's an offence to drive a vehicle without a valid license, but it is also an offence under the Road Traffic Act to allow someone to drive without a valid licence. So it's your responsibility to ensure that if an employee is driving on business or driving your vehicle, or anyone who's driving your vehicles, you need to know that they hold a valid licence. As the employer, you're vicariously liable for the actions of your employees during the course of their employment. So this check must be made even if the employee will be using their own vehicle for business travel. And if that's the case, then do also check that the personal vehicles are insured for business use. With the employee's permission, you can also check with the DVLA as to whether there are any endorsements on the license. And if someone already has 9 points on their license, you might want to make a note of this and check their details more regularly than for other staff. Bear in mind that the photos on licenses are only valid for 10 years. So the license will show the date it was issued and the expiry date of the photo, so do check that that hasn't expired. And licenses should also be renewed after disqualification at age 70 or over, if a new lorry or bus entitlement is obtained or is due to expire, and for medical reasons. Now, if the candidate holds a foreign license, it may not be valid in the UK. Licenses issued in the EU and EEA are allowed in the UK, provided the full entitlement to drive is shown. But time limits do apply in these circumstances, which are normally until age 70 or 3 years after becoming a resident, whichever is the longer. And the rules, if the employee will be driving a lorry or a minibus or a bus, the rules about driving licenses there are slightly different. Also, just be aware that you may well do eyesight checks for all employees who are using VDUs. There is no requirement that you do eyesight tests for people that drive on business. But to be legally fit to drive, all motorists have to be able to read a number plate made after the 1st of September 2001 from a distance of 20 metres. And it's illegal to drive if you're not wearing corrective lenses or glasses if these are needed. And if a motorist is caught driving without them, they could get penalty points and a fine, and their insurance is also invalidated. And if someone's killed in that accident and the driver wasn't wearing their glasses, the driver could be charged with death by dangerous driving. And that carries a penalty of 15 years in jail if they're found guilty. And the problem is that many people don't realise that their sight has deteriorated and is no longer legal. So, steps to take if you have people driving on business or driving your vehicles. Ask the candidate to produce their original driving licence and consider whether you need to check with the DVLA whether there are any endorsements on that licence. Look at the licence for any restrictions and validity in the UK, and check with the gov.uk website if you're unsure about whether a foreign licence is valid. Check the address details on the licence against any other documentation given to you by the employee, such as the application forms. Take a copy and date it. You might also need to review driving licenses regularly for your own insurance purposes, and we would recommend that you carry out checks at least annually. You'll also need to carry out a risk assessment for any employees who drive as part of their job. And do remember that different rules on working time apply to the drivers of large vehicles. You can get commercial organisations to run these checks for you if you prefer. Encourage your employees to have eyesight tests at least every 2 years, and do check the insurance documentation of anyone who is driving their personal vehicle on your business to ensure that they are covered for this. Should you make any checks of other qualifications? Well, educational attainments and qualifications are a key area where many candidates are tempted to lie or to improve their grades. And according to research by Forbes, 53% of resumes and job applications contain falsifications. In most cases, there's absolutely no legal requirement to check qualifications, such as academic qualifications or membership of a particular body. But if this is essential to do the job, or where your insurance policy requires that people have certain qualifications before undertaking a task, then clearly it's recommended that you ask to see the original certificate and take a copy. Often a degree or technical training is the only true indication of an applicant's knowledge or skill anyway. And also note that public sector workers in client-facing roles now have to have their English language competency checked. So steps to take about that. Well, first of all, identify which, if any, of your vacancies require particular qualifications or membership of a professional body in order for the person to do the job. If they do, ask the candidate to produce the original certification. If you're unsure, check with the awarding body, but do tell the candidate that you will be doing this. For degrees, you would normally go directly to the university or college registrars to check that the course does exist and the person attended it, and also to check the class of degree that they are claiming to have. And if you're unsure about that, there are third parties out there who have specialist knowledge of what are known as diploma mills. Now, these are websites that borrow wording and images from the original true sites. So if you were looking at one of these sites to see whether such a course existed, it may appear to do so, but you could consider using a third party to check that. Take and retain a copy for your records of any qualifications, certificates, and date this. And if membership is renewed, i.e. annually or every 5 or 10 years, then make a note of the expiry dates and recheck as appropriate. If accreditation needs to be renewed, such as with safe gas certification, then do ensure that this happens on time. Should you do any pre-employment health checks? Well, it is acceptable to require employees to have a pre-employment medical, as long as you treat everyone consistently. So you shouldn't be just asking people who are or appear to be of a certain age group to have a medical, as this could amount to discrimination. You don't have to have medicals for all of your staff, but you do have to have medicals for all of your staff who do the same job, if that's what you're going to do. Pre-employment medicals should only be arranged after an offer has been made and accepted, but they may be done before the employee starts work for you. And the main reasons for requiring a medical are to make sure that you're aware of any health conditions, and if there is a disability or any health considerations, to ensure that any reasonable adjustments are made to the employee's working conditions if required. There are some sectors where a health assessment is imperative before work can commence, for example, when working in a food factory. So effectively make sure that any tests you are undertaking are relevant to the job. Now, there might be situations where you want to withdraw an offer following an examination, for example, where a medical condition may be made worse by the job, such as someone with asthma working in a confined, dusty space, or where that condition presents an unacceptable risk to you, so someone with a back problem who's having to bend and lift heavy items. Other assessments may be done to confirm the level of the person's ability on joining you.
For example, noise assessments, which identify if someone already has a hearing problem and its extent. So, consider what tests, if any, are necessary to protect your business, and ensure that if you do test, that these are not directly or indirectly discriminatory. Warn your candidates in advance of any requirements for any tests, and consider using external occupational health assessors to provide impartial specialist advice. Give them full details of the role and the exact physical requirements. You can even send photographs if you like, and the nature of the working environment, because the better the idea they have of actually what's involved and what this person will be doing, the better the advice you will get. Night worker assessments. This may not apply to everybody, but if you have night workers, then under the working time regulations, you should not recruit someone into a job which is night work. And that's basically where the daily working time includes at least 3 hours of night time on the majority of the working days, unless you give the worker the opportunity, firstly, to have a free health assessment before they start night work, or unless they've already had an assessment and you've got no reason to believe that a further one is needed. And you also have to give them an opportunity to have a free health assessment at appropriate intervals thereafter. If you have night workers with medical problems which are considered by a medical professional to be connected with their night work, then you must, where possible, transfer them to day work, which they're suited to. So for night workers, identify all roles that would fall under the definition of night work and ensure that your recruiters are aware of these. Tell your candidates that their appointment is subject to a satisfactory night worker assessment, because you don't want to have to move a new person onto day work if you don't have a suitable vacancy for them. Consider whether to have a full assessment done by an occupational health specialist for all new recruits, or you can have an initial questionnaire which is followed up by a full medical for anyone who would be deemed to be at risk based on the answers that they're given you in the questionnaire. And keep records of the night worker assessment details or questionnaires on file, and ensure you have a procedure to renew these. Workplace drug and alcohol testing, both before and during employment, is pretty controversial and generally disliked, but it is becoming more common in the UK. And such testing is most appropriate for minimizing health and safety risks. So, for example, for drivers, pilots, people who operate heavy machinery, who work with cutting equipment, knives, other sharp implements, etc. Repeat tests can be routine, or it could well be that you only undertake them when you have a suspected problem, and where substance abuse could be a factor, or where under health and safety legislation you simply can't ignore that person's behavior. Random drug and alcohol testing of all employees is above and beyond this basic requirement in the workplace. So it is your role as an employer, depending on the job and the nature of your industry, to decide what is necessary, what's justified, and what is proportionate. So bear in mind when you're thinking about this that it is likely to be unpopular. And it's also likely to be seen as intrusive unless you can clearly justify why you're doing it. So in order to do that, you're going to need an impact assessment to ensure that any testing is proportionate to the risk identified and that there's no less intrusive or better way of achieving the aim of reducing the risks. And document your impact assessment. Then ensure that your employees are aware of the requirement for this testing and include this requirement in their contracts of employment. You will need to put proper controls in place to ensure the continued confidentiality of this data, including when it's destroyed, and to ensure that it's not used for a purpose other than that stated in the impact assessment. And you also need to consider what action you will take if an employee tests positive. It may not be so much of an issue prior to them joining you, it will be an issue once they're your employee. Hearing assessments? Well, there's no requirement under the noise at work regulations to check employees' hearing by compulsory audiometric testing. But if you work in an environment where hearing loss may be a problem, And where some of the applicants coming to you may already have suffered hearing damage during previous employment, then you might want to include an audiometric test as part of your recruitment process. That will give you a record of any hearing damage already suffered by the person, which may well be useful in a defence if that person later claims that their loss of hearing was due to working at your business. So, do you have any production areas, job roles, other areas where the noise level is an area of concern? And concern basically is above 80 decibels and above. If so, consider whether to undertake hearing assessments prior to employment starting and then at regular intervals thereafter. And do check that you're providing these workers with the appropriate protective clothing, such as ear defenders, and that they are wearing these as instructed. Criminal record checks, do you need to do those? Well, first of all, you need to know that according to the National Association for the Care and Resettlement of Offenders, NACRO, over 20% of the working age population in the UK has a criminal record. In addition to roles which involve working with children and vulnerable adults, there are other specific roles for which criminal records disclosures are required. And these include chartered and certified accountants, barristers, solicitors, those involved in the licensing of firearms, explosives, and gambling, and also professions such as pharmacy, health, law, and senior managers in banking and financial services. Now, there are three main bodies in the UK that provide disclosure information. We have the Disclosure and Barring Service, the DBS, in England and Wales. Scotland has Disclosure Scotland, and we also have Access NI in Northern Ireland. Now, whilst the rules differ, with all the three bodies, the candidates must consent to a check and they must provide the relevant information to conduct it. And the employer or an umbrella body normally submits the application except for a basic disclosure from Disclosure Scotland. And the authority then provides the results directly to the individual, not to the employer. Now, there are three types of check. A basic disclosure is exactly what it says on the tin, basic. It covers unspent cautions and convictions, and until next month, it's only available from Disclosure Scotland. Now, this is the most common disclosure, and there are no eligibility requirements for it, and the records are available to any individual who applies directly to Disclosure Scotland for information about themselves. The next step up is the standard disclosure. That covers spent and unspent convictions, cautions, warnings, and reprimands. And it's focused on more specific fields and industries such as NHS staff, legal and financial professions. And then the top level disclosure is the enhanced disclosure. And in addition to all of the information in a standard disclosure, it also covers any other relevant police data, and it checks the ISA barred lists for those who are working with vulnerable adults and children. So enhanced criminal record checks are more detailed, and they're used mainly for people working with vulnerable adults and children. If you're unsure as to whether you can make a criminal check, then gov.uk has a useful interactive calculator, which we can send you details of. And if all of your recruits are UK citizens, then these checks may be sufficient for you. But do note that they only disclose criminal records, spent and unspent, which relate to activity in the UK. So the DBS service doesn't cover any international criminal history or information from outside the UK. So if you have foreign applicants, then you may need to obtain a criminal record disclosure from that person's home country and possibly any other countries that they've lived in for 6 months or more. You can ask applicants from overseas to get a criminal records check or a certificate of good character from their country of origin. And it may also be possible to get these through the relevant embassy in the UK, but the applicant has to give you the permission. Processes for getting criminal records checks from abroad do vary between countries. So again, the gov.uk website has advice on this. Now, note also that any DBS check is accurate at the time it's requested,
So it's up to you to decide when it's appropriate to order a repeat check, typically annually in some sectors. And also, if you are in this particular circumstance, it's worth including a clause in your contracts that requires your employees to declare any criminal investigations or proceedings which arise during their employment. Note that it is a criminal offence for you to require your candidates or any existing employee who is applying for a promotion to obtain and disclose the results of a data access request from the police as a way of checking criminal records and, for example, obtaining details of spent convictions or cautions which you wouldn't otherwise have access to. So you can't ask your candidates to do that. Now, there are some changes on this. So Disclosure Scotland currently processes basic disclosures for Scotland, England and Wales. And it uses different filtering rules depending on where the application is coming from. So it applies Scottish filtering rules to those for Scotland, and it applies the appropriate ones to England and Wales. As from next month, it will be processing basic disclosure applications using only the Scotland filtering rules and in respect of people who live or work in Scotland. So from the 1st of September, applications for basic disclosures for candidates who live or work in England and Wales must be made to the Disclosure and Barring Service so that the correct filtering rules can be applied. Filtering is where you take out spent and unspent convictions. The certificate will still be sent to the candidate, but you will need to see this for the details. So the DBS is also going to provide candidates with a PIN for their basic disclosure certificates, which they can then share with their employer so that the employer can view the certificate online. Now, we've had lots of questions about the impact of the GDPR on criminal records checks, and this does seem to be a bit of a movable feast at the moment. It is still currently unclear as to how the GDPR may affect criminal records checks, but it looks at the moment as if things will continue as normal. Now, I think I probably need to say a little bit more about that because the GDPR is close to everybody's hearts at the moment. Under the GDPR, which comes into effect next May, data relating to convictions and offences will no longer be classed as sensitive data. It never was under the Data Protection Directive, and the rules in the GDPR mirror the directive. But in the UK, our Data Protection Act regarded convictions and criminal records as sensitive personal data. Now, under the GDPR, these checks have their own section, which is Article 10. And what that says is that information about criminal records comes under the control of official authority or where that processing is authorised by law. It can be either EU law or by law within the member state, which provides appropriate safeguards for the rights and freedoms of the data subject. So effectively, what the GDPR says is that criminal records checks can only be undertaken if there is a relevant law in that member state which justifies that processing. Now, in the UK, the Police Act 1997 is going to cover quite a lot of that and is likely to provide a sufficient basis for checks for roles which involve work with vulnerable adults or children, or the checks that are required by law for some professions, but it does leave the voluntary checks in limbo at the moment. Member states are allowed to authorise the use of criminal records checks in other circumstances, but a lot of advisors have been saying that we won't be able to continue doing voluntary checks unless these were a legal requirement, because the government hasn't legislated yet to allow for this. So consent won't be a valid ground for processing data relating to criminal convictions. So under the GDPR, employers cannot request a check even if the employee agrees to it. However, the government published a statement of intent on the 7th of August on the Data Protection Bill, which is the legislation which it is using to bring the GDPR into effect in the UK. And it's confirmed within that statement that it considers the current law on the processing of criminal convictions and offences has worked effectively, and to lose this on the part of private or third sector organisations would be significant and a negative move. Therefore, it intends to legislate to extend the right to process personal data on criminal convictions and offences to enable organisations other than the ones vested with the official authority to continue to process this data. So that's a very long-winded way of saying basically that it looks as if we're going to be able to continue with DBS checks as currently. But do note also that under the GDPR, if your core activities involve large-scale processing of either sensitive data or criminal records, you will need to appoint a data protection officer. Examples of large-scale processing include banks, insurance companies who process customer data. So, steps to take about criminal records. Well, consider whether you have any posts that require a DBS check before the person commences work. If so, notify the applicants of this requirement and make it a condition of your offer. If you're not registered with the DBS, you will need to identify an umbrella body which can process the necessary paperwork for you. And if you're going to be making fewer than 100 checks each year, then you would normally use an umbrella body. Remember that this data is currently sensitive personal data, and the details are highly confidential, and you must have much stricter rules for ensuring that they remain so. Never require a candidate to make a subject access request to obtain their own criminal record and provide that to you. Consider using third-party screening providers, especially for international checks. And don't turn somebody down if they've been convicted of an offence if that's spent, unless an exception applies. Include a clause in your contracts that requires the employee to inform you if there are any changes in their DBS check and any criminal investigations or proceedings which arise during their employment, and decide whether you're going to need follow-up checks or not, for example, annually. Now, if you work with children and vulnerable adults, then you will be well aware of this bit of information, so I'll cover this fairly quickly. But the vetting and barring scheme maintains lists of those who present a potential risk to children and or vulnerable adults, and bars them from working with them. And it is a criminal offence for anyone on a barred list to either apply for or take up work with vulnerable groups. It's also a criminal offence for the employer to knowingly take them on. Now, if you provide care services for adults, for example, in a care home or via a domiciliary care agency, then there is now a new service called DBS Adult First. And this will confirm, usually within 2 days, whether an applicant can start work supervised or whether you should wait for the results of an enhanced check. Now, that costs an extra £6, and it's not appropriate if your employee is going to work with both children and adults, but where that applies, you must wait for the DBS certificate to be returned, but it could help those who are recruiting people purely to work with adults. So if you work with children and vulnerable adults, then define the jobs that require further checks with the barred lists. Ensure that your recruitment literature informs all candidates if a DBS check is required for the specified vacancy and at what level. Ensure that your application forms request information as to whether the candidate is on a relevant barred list or not. Cover that at interview. Keep any data securely and confidentially. It is sensitive personal data, so you do have stricter rules. And create a process to document and report unsuitable individuals to the DBS. Now we're getting on to the less common checks, yeah? So credit reference checks, identity checks, not as common as any of the things we've spoken about earlier. But if you have a role which requires the employee to handle money or cash, or where the person is in a position of significant financial trust, you might feel it appropriate to have a credit reference check or an identity check. It also provides proof of ID, and it will highlight whether the person's previously been involved in fraud, has been declared bankrupt, has any county court judgments against them, or has been rejected for credit. Now, obviously, you would only do this if this check was relevant to the job, and it wouldn't be reasonable to ask for a credit check for all roles. And you also need the employee's prior written permission for this. So these checks are common in the financial services sector because the FCA and the PRA require them, to make sure that those working in the sector are fit and proper. They're also common for directors because you want to ensure that the person hasn't been declared bankrupt. But for other roles, the concern usually is whether, if the candidate is in a poor financial state, are they going to easily be able, and are they going to be more likely to commit theft?
Now, there are commercial organizations, Experian is probably the most well-known, that you can use to do the checks, or alternatively, you can ask the employee to have a check done and to provide this to you, and then you can reimburse the employee for the cost of the check. So for these checks, identify any roles that require credit checks, ensure that you have informed consent before taking up such checks, review any information that isn't clear and consider the type of debt, and decide if you need any ongoing checks of credit history or other checks. Now, the final thing that I'm going to be looking at is social media screening, because there are 38 million active social media users in the UK. So that's a large proportion of our workforce. And we've all read stories in the media where unsuspecting bosses read highly unflattering accounts of their activities or behaviour on their employees' Facebook pages. But 36% of UK employers have rejected a candidate based on something that they've put on Facebook, Twitter, Instagram, or LinkedIn. Many professional recruiters do routinely check candidates' LinkedIn profiles these days, and this has gained popularity over the past few years. And that's not usually viewed negatively because LinkedIn is a site for professional networking. But others do look at other social media, especially Facebook, and the question has to be, is this too intrusive? Is Facebook more of a personal thing? And they also run searches, Google searches, and look at any websites which feature the employee. Now, these can often give you a good indication about the person, their achievements, their membership of particular groups or activities, social activities, but it isn't unlawful, but the question has to be, is it relevant to the job? So if you're going to be doing this, do consider whether it's fair. Yeah, which sites are you going to search on, and is this a fair way of vetting candidates? Note that your candidates may well post comments that reveal unlawful or racist or intolerant or sexually explicit references. Now, these do say something about the candidate, but it is their personal life. On the positive side, you might see comments that demonstrate good written or IT skills, a good culture fit, or other attributes that are actually relevant to success in the role. On the negative side, they may reveal drug use or the disclosure of confidential information. So if you're going to do this, do think how you will use this information. And again, you may well want to warn your candidates that that is a standard part of your recruitment process, and people who don't like that or who have things to hide can think about whether they want to pursue the application. Now, if you're going to be running all of these tests, then clearly it's sensible to set out what you're doing and when and for whom in either your recruitment and selection policy or a separate policy or just a set of guidelines for your recruiting managers. Yeah. And this should set out the checks that you're going to carry out for which positions and how the results of the tests will affect recruitment decisions and also disciplinary decisions. So if you have clear processes, that will help to avoid any inadvertent discrimination. You're also going to need to take care regarding sensitive personal information to ensure compliance with data protection laws. So sensitive personal information should only be disclosed to those who absolutely need to know, and you should have robust procedures in place to ensure its confidentiality, its storage, and its safe destruction. And you should only be keeping the test results for as long as necessary. If you have things like hearing assessments or other health and safety assessments, as long as necessary may be quite a long period, up to 40 years in some cases. But in the case of references, you probably don't need these after the person successfully completed their probationary period. And you only need copies of the most recent driving license and insurance documentation, etc. So look at best practice and key areas of risk when you're deciding which tests to have. Determine which types and what level of employee will be subject to background checks and why, and then use those rules consistently across all recruitment to those posts. Any tests you undertake should be proportionate, so don't go any further than you need to. Determine when in the recruitment process you're going to conduct the checks. Are you going to do this before or after an offer is made? Because that will affect, obviously, the costing, and the time that you spend on this, but it also may affect how you conduct some of those checks. Be transparent. Explain the process for how the background checks will be performed and reviewed. Ensure you have your candidates' consent to this and know why you're doing it and what you're going to do with their data, where you're going to store it, and for how long you're going to keep it and who will have access to it. And then follow clear data storage and retention rules and ensure that you do dispose of any data once it's no longer needed. We've covered a lot of different types of checks in this hour, and except for checking the right to work in the UK, which is clearly required for all roles, not all of the checks that we've discussed will be appropriate or necessary. So the key is to identify the ones which are essential for the role or which are going to give you some really useful, good information to assist you in making a good appointment. Also, to apply a fair process by not singling out individuals for specific checks, but applying them to all applicants for a specific type of role. And the final consideration is whether you actually undertake the checks in-house or you outsource some of them. And then, since this webinar is all about reducing risk, it's not just your employees, but also consider agency workers and contractors. Who is responsible for ensuring a similar level of robustness when checking their details? Now, don't forget, as a Hiscox policyholder, you have access to our portal, and we have pages which give further information on DBS checks, checking the right to work in the UK, the details of the lists, employing foreign workers, taking up references and template forms for that. We have night worker assessment forms. We have information on working with young people and children, guidance on noise at work, and safeguarding vulnerable groups. So do take a look at the ones which are relevant to you in case they help you. Now, I was going to ask for any questions, but we are very, very short of time. I think we're running up to the hour at the moment. So if you do have any questions, please do email us and we will get back to you as soon as possible. It may not be today, but we will deal with it as soon as we can. And it remains for me to say thank you for attending. We do hope you found it useful and informative. We've covered loads of stuff, so copies of the slides and a recording of the webinar will be available soon for those who want it. Our next webinar is planned for Tuesday, the 19th of September, and we'll be looking at steps to try and keep you out of tribunals. So do join us. We'll be sending out invitations via the usual emails at the beginning of next month, and we hope you found this session useful, informative, that you've picked up a few tips. Have a good afternoon. Bye-bye.